Good afternoon and welcome. My name is Caitlin Morgan and I am a staff attorney with the Unemployment Law Project. The Unemployment Law Project is the only freestanding legal aid society in the United States solely devoted to unemployment. Our office provides free legal representation and advice to people whose benefits have been denied by Washington State or whose benefits have been otherwise challenged. We are here today with our weekly webinar. It occurs every Monday at noon. The purpose of the webinar is to share the latest news about unemployment benefits and to answer your questions. I will be monitoring the Q&A chat box and I will share the questions that are commonly asked. For questions that may be unique to your situation, you are welcome to call our office and one of our staff will try to assist you. I'd like to introduce today's speakers from the Unemployment Law Project. We have Executive Director John Turpak and Staff Attorney and Policy Director Ann Paxton. John, I will turn it over to you now.
Well, the big news of the week is the signing of the COVID relief bill, and Ann will talk about the details. Like all big pieces of legislation, it's makes some people happy, some people upset, but the Biden administration tried to get as much as they could for passage. There were some conservative Democrats who would not vote for things like adding a minimum wage increase or increasing the $300 extra unemployment benefit to $400. So the good news is that there is some tax relief in there, and there's the benefits, the pandemic unemployment benefits would go longer than they would have. So I want to turn it over to Ann to give an update on what is happening on that.
Thanks, John, and thanks, Caitlin. Welcome to our weekly webinar. So what happened with the American Rescue Plan is all very interesting. So there were differences between the Senate bill that passed and the House bill. So after the bill passed the Senate, had to go back to the House, they worked out their differences and sent it to the president, and it was signed last week. So this extends the current unemployment provisions, that is the Extended Benefits Program, PEUC, PUA, and an additional program through the week ending September 4th. And so under that, the supplemental benefits will continue at $300, which is where they were set with the Continued Assistance Act. But the PUA benefits have been extended for a longer duration now. They have been 50 weeks. They will now go up to 79 weeks, which confusingly might be past September 4th, but it hasn't been clarified exactly how those will be reconciled. And PEUC has been increased from 24 weeks to 53 weeks. So that is the extended benefit. And that's going to affect a lot of people in Washington and every state, because a lot of states extended benefits, that's a special program that always exists. Those benefits are running out and people will have to be transferred to the PEUC program. But now with the signing of this bill, there is protection to assure that happens. I mentioned before the mixed earner unemployment compensation is a new provision, which adds $100 to that $300 add-on for people who have $5,000, at least $5,000 of self-employment income in addition to their W-2 income. Those people have been a little bit sidelined in terms of benefits because they couldn't combine their income sources. So that's been sort of a long-term inequity that they've tried to address with this mixed earner benefit. As John mentioned, the first $10,200 of unemployment benefits in 2020 only are tax-free for people who have less than $150,000 in income. And of course, most people know, and in fact, some people might have already started receiving the stimulus payments of $1,400, which go to people who have under an income of $75,000 or $160,000 in joint income. It requires a Social Security number in most cases, but the earlier benefit did not allow any stimulus payment to people who had a spouse who didn't have a social security number. That's been changed. So if one spouse has a social security number, they will get that payment. And there's a more generous child tax credit. So these are not unemployment benefits, but they're very supplemental, very related to unemployment. And a lot of the same people are in need of funds and are going to benefit. So this will be up to $3,000 per child, an increase from $2,000, and it will be $3,600 for ages 5 and under. This is such a dramatic benefit that it's estimated it will almost cut in half the rate of child poverty in the United States, which is very high among developed nations. So the Employment Security Department, in terms of advice for what to do now, they are saying, this is very hopeful, they do not expect most claimants to experience a gap in benefits. So that probably applies to you if you've had little problem with your benefits all along. As long as you remain eligible and as long as you continue to submit weekly claims. So that is a very important thing that they emphasize. They ask people to look at their e-services account for regular updates, and they may be sending emails and messages through e-services. And of course, they do not suggest calling the Claims Center for help, just because call volumes remain very high. That's up to you, of course. Sometimes people can get through if you have a lot of questions, which everybody will. So just to mention this issue about the PEUC conversion, if you're already receiving extended benefits, those have actually been ended because Washington State technically has a low enough unemployment rate that we don't actually fit the category of extended benefits now. So now that this bill, the stimulus bill, has been signed into law, people who are on extended benefits can be converted over to the PEUC program. So they'll be able to continue receiving those benefits. So I wanted to mention next the status of the bills that we've been working on in the state legislature, because these are happening kind of in parallel with what's been going on at the federal level. But these are not reality yet. So we're still, the session is still continuing, but many things have already been decided. In one case, the bill that we had hoped to see some progress on, Senate Bill 5064, which would have changed the voluntary quit laws to add a provision for people who have found that their hours at work are making childcare inaccessible, or other care they have to perform in their family. That bill did not get any passage in the Senate or the House, and that is past the deadline now, so it will not. It's off the grid for this session. However, the other bill that we also consider very important is Senate Bill 5193. That has passed the Senate, not in the form that we had helped draft. It has extensive changes that would improve claims processing. So it's been whittled down. However, the House is considering it and may restore some of those provisions. We're very hopeful about that. The original had several provisions that were mandatory, required. You would have been required, the ESD would have been required to have translated all of its notices to unemployment benefits, about unemployment benefits, into the top 10 languages in Washington State. So that was deleted. There was another requirement, and that there are still some remaining requirements to improve communications with people of limited English. But one of the really important requirements is still in there, and that is to make the notices, to show that the notices and letters that are going to claimants are comprehensible. Now, this has been, obviously, everyone has had a problem with this, and I'll talk in a minute about the latest example we've gotten regarding overpayments. So it's a chronic issue. We really wanted to make sure that there was some accountability on this. Not that it was just the staff approving the notices for plain English, but the claimants were saying, yeah, that's in plain English and I understand it. So that is still in there. Again, this hasn't passed yet, but it's being seriously considered. And another provision, we wanted to have a data dashboard that is bigger than the one they have now, that would include, right now we have a lot of metrics about the ESD's performance and other things, the rate of unemployment, the number of claims that have been paid, and so on. We were asking for more regular reporting of backlogs in claims that are languishing in adjudication, claims that are pending appeals, claims that have been denied. Also, the recipiency rate, which is what percentage of people who are unemployed are actually getting benefits. Very important metric that doesn't get mentioned very much, but it should be. It's been very high actually in 2020 because so many people did qualify for benefits. Usually, it's only about 25% of the people who are unemployed in the state actually get benefits. And that's something we've really made a goal to increase. So right now, the data dashboard is included, but it is set with a 5% unemployment trigger. So it wouldn't be in place during periods of lower unemployment. And just for perspective on that, that means the 4 years preceding the pandemic would not have had any of these metrics required. By the way, not only including performance measures like backlogs, but also staffing levels. And the idea being that these could be correlated and in a way that people could see whether their staffing was affecting their ability to process claims at the level that's needed. So we're hoping to have those metrics available both at times of high unemployment and low unemployment. And call volume is another thing, what kind of hold times people are experiencing. And overpayment information. All of this is information that is collected. It's just a matter of making it available to the public, to the legislature, without going through a process of public records request or Freedom of Information Act type request, which is very lengthy. The requirement to set up a training program for adjudicators, that's still in the proposed bill as well. We're hoping very much that these other provisions will be restored, and we can look forward to some real progress in improving claims processing. I wanted to mention, as I mentioned, there was a really interesting overpayment letter that came out that we just discovered in the last week that really shows how drastically in need of revision and comprehensibility these notices are. And this was actually not too incomprehensible, but it was very difficult to understand in the context of right now, the department has been saying there's no collections going on in overpayments. They've had those on hold because of the difficulties and a lot of kind of contradictory policies. And one example is a lot of people received notices about overpayments when they actually were just in the wrong program, and there might be a small overpayment, but not a big one. So that was one area where the messages were misleading. But this notice starts out with extremely threatening language and saying, you owe the Employment Security Department $10,500 if you don't repay the full amount, or we don't receive a payment of $1,100 by March 30th, we will start legal action against you in Superior Court. Under state law, once we begin legal action, a lien will be placed on all of your real and personal property. That includes wages, bank accounts, and other property. So this is called a pre-lien, meaning an action against your finances. Pre-lien letter, and it's very threatening, and obviously it's unsettling a lot of people. And part of one of the issues with comprehensibility is it's difficult to make sure that the individual notices are comprehensible, sure, but then the fact that there's a sequence of notices that may just not make any sense when they appear. The Employment Security Department sends out millions of notices every year, usually from the computer. And this kind of flood of notices can be compounding the confusion. As I mentioned, the collections in overpayment has allegedly been halted, but these overpayment letters are still going out. In some cases, the department has added notices to say, because it's aware of this problem, to say, please disregard an overpayment notice you may have received if you, for example, never received any benefits. That makes sense. Or if you were a victim of fraud. But that contradicts with other notices that say, do not ignore an overpayment notice. so this is a situation that really we're hoping to see will get addressed before the next crisis happens. We're looking at a possible decline in the amount of unemployment as the pandemic sort of resolves, as we hope it will. But this is the next recession is always predictable. It's just not. It's inevitable, but the timing is not predictable. So we want to be hopefully ready for this if it ever happens again, and it will. So the Biden administration has made some significant changes in its policy on PUA eligibility, and most of these relate to worker safety. So in the past, unless you had a directly COVID-related reason, for example, if you had COVID, you were not allowed to, in many cases, it was difficult to decline work because of worker safety issues. In Washington, we have better laws on that because suitable work is defined as work that is appropriately safe. And you can actually quit a job if there is a drastic decline in safety. But now this new DOL policy, the Department of Labor policy, allows people to decline work right now without waiting. They don't have to try it out. They can decline it right at the beginning if the potential employer does not comply with local or state COVID safety standards, that is social distancing, mask wearing, or personal protection equipment. And workers who have been laid off or had their hours reduced because their employer has closed or partially closed due to COVID can also qualify. Both of these groups can qualify for PUA. Now, and this is an expansion over the policy that was in place last year. And interestingly, this is another retroactive benefit. So it goes all the way back to the passage of the CARES Act in March of 2020. So in many cases, this will mean that people will get back payments, and in some cases quite substantial. And the department all the state departments of unemployment benefits are required to notify claimants who may have been turned down on their application for PUA of the availability of this new broadened eligibility. So that could affect a large number of people, and on an individual basis, very significant levels of benefits could be available. In fact, a lot of people are expected to get a large lump sum payment near the end of March, but there's no guarantees on this because the state agencies obviously take a few weeks to implement the changes, and we've already been warned that will take a while. There is funding, though, for states there's about 100,000 per state available to implement these changes with the IT systems. So hoping that will be happening soon. And finally, I just wanted to mention again, very important resources. One is the Seattle Public Library's Assistance Program. And we don't want to pile onto the library. They've been so helpful to everyone, especially throughout the states. The libraries have been very helpful, along with the WorkSource programs, which are closed. So now that things are gearing up again, the Seattle Public Library started in January offering, late December, offering assistance if you have a new claim. Unfortunately, they can't help people who have an existing claim and are having trouble with it at ESD. But what they offer is advice over the phone. You can sign up even for an appointment with a librarian if you're confused by the application. That affects a lot of people who may not understand computers, don't understand the information that's available online. They also offer, and this is for Seattle, but there are hopes that this will broaden out to other libraries in the state. They offer free printing of digital documents for curbside pickup. So in some cases that will help people with their applications who need to upload information or have other reasons to have documents printed out. They will print up to 10 pages. So it's it's extremely helpful at the library to do that. Librarians are just by nature a very helpful occupation, and they've really pitched in. In the past, they've been very willing to help people who have trouble with with operating the computer at the library, especially when they're applying for benefits. So this has been created a big gap in actually services that have been available. And then I also wanted to mention also Lavina Statton's TikToks. She's one of our attorneys. She's done a very comprehensive and really quite brilliant series of TikToks updating people on what the changes in the law are, doing Spanish language TikToks, giving the basics of unemployment as well as English TikToks. And I think Erin was going to post the links for both the Seattle Public Library and for Lavina's TikToks. And I think she has the latest one is on the implications of the stimulus bill. So very current. So that's the news.
Great, thanks so much, Anne. That's really, really helpful information. We do have some questions in the chat box. The first question is, if a claimant didn't appeal because maybe they didn't realize that they could, can they still request a waiver of an overpayment? And does ULP take cases like that?
Well, if they didn't get the original notice with the hearing rights, they could file for the hearing and the judge will consider whether there's good cause for the late appeal. If the notice is about an overpayment and it doesn't say you're eligible for waiver or waiver is going to be considered, they won't consider a waiver unless there's a hearing, because what they do in these letters usually is say you are at fault, and fault is one of the elements of the rule, that if there's a finding of fault, then they won't even look at your financial hardship. So it would be best to file for a hearing. It would be late, but a judge may or may not consider it good cause for being late. You can, of course, try contacting ESD to request a waiver. I would not be too optimistic about that, but it's an option that you can try. As far as doing these cases, yes, we do many hearings that involve overpayments and appeals that are late.
Great, thanks, John. The next question is a general question about unemployment for self-employed people. Let's see, the person's understanding was that self-employed people were eligible for unemployment benefits during the pandemic. They want to know how that works and how someone might apply for that.
So traditionally, unemployment has not been available to people who are self-employed. But under the Pandemic Unemployment Assistance, the CARES Act provided that PUA would be available to people who are self-employed and to gig workers. In Washington State, we actually consider a lot of gig workers to be employees. So they are treated like people with W-2 benefits. And in many cases, they might be receiving regular benefits. But that PUA program also applies to people who are part-time, have fewer than 680 hours, or other reasons that a couple of other reasons that they were denied regular UI benefits. That program has been extended now till the week ending September 4th. So those benefits should be available.
Okay, the next question is about PEUC benefits and how you know whether you have exhausted your regular unemployment benefits. This person says their benefit year ends on March 13th, but their SAW account indicates they still have a positive balance. So they want to know, would that be just because their benefit year is ending? Are they considered exhausted as far as their UI benefits are concerned? Are they eligible for PEUC? And if they don't see a link on their SAW account for PEUC, what should they do?
So I can't answer that in terms of the current law. It is very confusing. There's actually a bill requested by the Employment Security Department to clarify the status of people who are in these sort of between situations where their benefit years ended and their eligibility may still be available. So I would have to research that to find out more about whether what the status is. The weeks are there, so the department, I believe the department should be able to make those available, but I don't know if they can do it right away. There is a bill that will likely pass that will fix some of these issues.
Thank you. The next question is about unemployment benefits and whether they are taxable. So this person says that they heard that benefits are non-taxable retroactively. Just generally, it's kind of a confusing situation. They want to know how the IRS will deal with this, and if they've already submitted their income tax returns, do they need to submit an amended return, and how does that work?
I haven't heard advice yet on submitting an amended return. Somehow you want to let the IRS know that those were unemployment benefits and you would like to obviously get the tax break. So you should qualify for $10,200 deductible from if you've been paying paying that taxes on that. That unemployment has been taxable since the 1980s, but that provision, that for 2020, people who received unemployment benefits should not be taxed at the federal level, not necessarily state level. They shouldn't be federally taxed up to $10,200.
Thanks, Anne. There's kind of a follow-up question, well, about overpayments. Given the huge number of people who are potentially in danger of experiencing and getting an overpayment letter, as you described, what is ULP doing about that? Are we taking any action as far as advocating for Washingtonians? Have we requested a meeting with the governor's office? What can we do?
So we had actually worked on some possible legislation. It didn't get very far this session. We've also been meeting regularly with the SD to try to get a lot of, we see a lot of the finer issues in the decisions we get from the appeals that we help with. There's a lot of punishment going on of claimants who are, in our view, are totally without fault and really deserving of a waiver. So this is something we work on with a lot of our cases. We have overpayment issues where if there's a negative decision, many cases the benefits have been paid and people are expected to pay them back. So you can always do more, but it's definitely an issue we are trying to work on.
Yes, indeed. This is a comment.
I'd like to add just a few things. We did do letters to the governor. I have emailed people in the governor's office. We've had meetings with the ESD to bring up these issues. And unfortunately, I'm not getting much encouragement of any changes coming. So I would encourage all of you to write to your state senator, your state representatives, and the governor's office about these issues, whether it be for yourself or for others. I recently shared some information about these overpayment notice with members of the press, and I don't know if there'll be coverage of it. There have been some coverage about overpayments recently, but it needs to come to fore, because I think that ESD is just telling people we are not doing collections, and the people they tell it to are believing that, and then they think the issue is resolved, even though it's not resolved.
And there were a few press stories last week and the week before about the level of overpayments. The acting commissioner said there are currently 55,000 overpayment letters out. So it's really a serious problem.
Okay, thanks. This next question is more of a comment. The King County law that says the King County library system does have some updates, up to 10 pages free printing per week, pick up at the curbside at many locations, in addition to 6 libraries that are open with limited hours. So outside of Seattle, it looks like the library system is also offering quite a bit of assistance.
That's great. Good to hear.
The next question is about DOL policies with possible retroactive benefits. Do you can you talk about 2 DOL policies with possible retroactive benefits, if you have information about that?
Yes, it's very, very technical. But essentially, they have said, okay, give me 1 second. So the CARES Act from the beginning said that benefits will be retroactive, even if you can't get through, you can't get your application in, you don't know how to file. The idea of the law was that they would be retroactive to when you became eligible after March 13th, something like that. So if you were eligible in April, but you couldn't file until June or July, theoretically, that it was still supposed to be retroactive. You were still supposed to be, your eligibility was still supposed to be considered, but that fell through the cracks in a lot of states. And even in Washington, we heard in many cases, people were being asked for good cause for filing late if they filed in September, for example. And there could be so many reasons why this happened, because many people, just for the flat reason that they had something they had to clarify through the claim center through a phone call, and they could not get through. So, but now they have been specifically said this worker safety expansion is retroactive, in addition to the other provisions under the CARES Act. So those are considered to have been in effect since the CARES Act passed. And people, in theory, will be eligible. They will not have to prove good cause for filing late. But that doesn't mean they won't have trouble, because that's something we've seen. Unfortunately, the law and the practice doesn't always sync up.
This question goes back to the tax question. Basically, it's just expressing a concern that information about the retroactive rule does not seem to be widely disseminated or known. This person had their taxes done by United Way volunteers who apparently didn't know about it. So they kind of just want to know, when did we know about it? And really, how can this information be better disseminated to the public?
Well, the tax break just came last Friday, really, because it just took effect on, I think, actually Friday, March 13th, Saturday. So we didn't know about it before that, but the communications have not been very good on any of these, and especially on this guideline from the Department of Labor. Many people in the government itself, in the agency itself, don't know about the unemployment insurance policy letters that are sent out by the Department of Labor. Those are really important because they are interpreting the CARES Act. And from the last administration had its interpretations, and now we have a new set. And these are much more liberal interpretations, but a lot of people don't know that. So we're trying to get the word out about that. They're very important, but they're very underplayed. I've talked to very few reporters that even know they exist and how important they are. So we need better.
I mean, I don't know, like people who do tax filing, what information or updates they get from the IRS, but I'm not a tax attorney, but I'm just generally aware, or I've heard over the years, that people can revise their tax form, that if you submit your taxes and there's changes or new information, it can be revised. So I would, if someone's already filed their taxes, to contact the preparer to do a revised thing. That might be the best way to do it in individual cases. I'm sure H&R Block and other professional places are updated as to any new tax exemptions. But this webinar is part of our effort to publicize it, and I think it's something that if people in this webinar are part of organizations or know contacts that can be made, it would be good to share that information.
Yeah.
Thank you, John and Anne. This looks like it's the last question. This person is really expressing concerns and brings up a good issue, having to do with having to quit your job and move because of the pandemic, having pandemic related reasons to move, expressing some concern that HB 5061 did not include moving due to pandemic-related reasons as good cause to quit, and wondering if you can recommend any strategy for dealing with that. Because right now it looks like the only remedy is an appeal, which would probably fail, and a letter to the Washington legislators. Is there anything else that can be done?
Yeah, it's really a difficult problem. Washington actually does have good voluntary quit good causes to a degree, because worker safety is not allowed as a good cause in some states. Also, if you have an illness, that is obviously a good cause for quit. And the good causes were expanded to include people at high risk and people who reside with people at high risk through a bill that was requested by the governor, SB 5061, and that has passed. I don't have the effective date. It may not be in effect yet. But so there are some increased provisions. These are still very difficult issues though.
And this is kind of related. A person is noting that that claimants who do fall within that category, there's also the possibility of having their benefits suspended pending an adjudication for identity verification, which brings up the issue that identity verification issues seem to be becoming more of a problem now. This is undue hardship. Do you have any comments on that?
We haven't heard about it letting up, actually. So it's been a problem, a chronic issue, right from the word go. A lot of people, in fact, this was one of the reasons we were involved in litigation against the Employment Security Department, because many people's benefits were frozen unfairly because of verification of identity issues. And those have been in many cases there are many instances where they have not been restored yet. So it's continued to be an issue, and it's something that, again, it's very important to get in touch with your legislators and let them know that this is one of the big causes of the logjam of benefits. This insistence on having verification of identity, and the procedures for verifying identity have been very patchy. Many people have submitted over and over their passports, their driver's license, and so on, and have either not received acknowledgement or just to find that there's no effect. So there really are a lot of continuing issues here.
Thank you, Anne. I think that was the last question. If we don't have any other questions, I think that will wrap it up today. Thank you, everybody, for joining us, and we will see you next Monday.
Thank you.